Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Martin Shanebaum, and Martin is an attorney specializing in civil and criminal tax litigation. His law firm, Martin A. Shanebaum, a professional law corporation, has been serving the national and international community in civil and criminal tax-related matters for over 30 years. Martin was formerly Assistant United States Attorney in the Northern District of California, Tax Division, and formerly an IRS Regional Counsel trial attorney. Mr. Shanebaum and his team of professionals prevent civil tax controversies from becoming criminal matters and battle the government for individual clients, corporations, and other business entities. Today I've asked Martin to provide some guidance about appealing an IRS tax audit and contesting an audit in tax court. And we're going to be covering highlights of a complex subject, so we want you to consult with a qualified tax advisor about your situation. Martin, thank you for joining me.
My pleasure. Thank you for having me.
Great. Okay, Martin, in another program, folks, we talked about undergoing a tax audit. You can find it online at financialinsiderweekly.com under past episodes. So when that tax audit is completed and you don't agree with the IRS's proposed adjustments, what's the next step?
Well, you can appeal an IRS revenue agent report, and the IRS will issue you a 30-day letter, and you can protest that letter to appeals. But is it wise? Why do I say that? I say that because if you go to appeals under a 30-day letter, there's no pressure on appeals to give the taxpayer a break. Many times appeals might just confirm the revenue agent report with slight modification. So what is the better procedure, at least in my view, which I've practiced over 30 years on? I would ask the IRS to issue a 90-day letter. Now, what's that? That's a ticket to admission to the tax court, United States Tax Court. And why do I say that? I say that because you file a petition within 90 days of the notice of deficiency. You get 90 days. You might get 150 days if you're outside the country, but normally you get 90 days. You file this tax court petition. You don't have to pay any tax. You just have to pay the filing fee. Petition goes to Washington, D.C., and you request a place of trial. If you're in the San Francisco area, you request San Francisco. Then what happens, the case goes to IRS counsel. IRS counsel is located, they have an office here in San Jose, but they also have the main office in San Francisco. They get the file. Once the tax court gets the tax court petition, they issue the file. They see where you requested the place of trial. Goes to San Francisco. The lawyer for the IRS files an answer. Once the answer is filed, he or she wraps up the administrative file, which is all the information provided during the audit, and sends it over to appeals. Now, appeals is under pressure. Why? Tax court has deadlines, and so the appeals has to consider that if they don't do certain things within time limits, it's going to go to trial. So they also have the ability to settle the case on hazards of litigation, and of course, and sometimes on nuisance value, but most of the time on hazards of litigation. So you have to be well prepared, understand your case, have the documents ready. Today, they will not look at new stuff. They'll send it back to the field. This may be a good maneuver at times if the statute of limitations is about to run, because you could delay it. But normally what happens is they'll look at the information. You'll have a conference. There's a new procedure coming out that face-to-face conference is going to become less. It's going to be on the telephone or video, whatever. But assuming you get a face-to-face conference, you need to have a qualified representative represent you at the appeals If you, as the taxpayer, go by yourself, you don't really understand the question or the issue of litigating hazard. A competent lawyer will understand that and push that issue so that the appeals officer might not want to consider to go to trial. I mean, in a fraud kind of case, the government has the burden of proof, which is by clear and convincing evidence. Normally, if you go to tax court, the taxpayer has the burden of proof by preponderance of the evidence. So in a case where you have a fraud case, you might want to be pressing the fact that the government has the burden of proof. And over the years, we've been pretty successful on the litigating hazard aspects when the government is asserting fraud. Mm-hmm. I mean, you might end up with a negligence penalty, but that's much less than the 75% of the understated tax. Mm-hmm. So you would be able to, resolve the case. You provide some information, and you argue the strengths of the taxpayer, and the government looks at the big picture and says, well, the litigating hazard produces a certain amount of percentage. I mean, sometimes the government will settle 50-50, sometimes they want 70%, sometimes you get 70%, but it's all based upon a competent representative being able to understand what's happening at appeals and what sensitivities they have.
Okay. Why would appeals decide any differently from the original audit report? So they've, this agent is supposedly well informed on the tax laws and so forth, and writes this thing up, comes to conclusions and so forth. Why would appeals decide any differently?
Because appeals has more discretion, more latitude. They have the ability to go litigating hazard. And at least in one case where appeals was considering it, and we had certain documents, and appeals said, well, I've never seen these documents. And we pointed out, and this was a case where the CPA was with me, mm-hmm. And the CPA said, during the audit, I provided these documents. Mm-hmm. Appeals officer looked at the file all the way through, top to bottom, couldn't find the documents, and couldn't find any record that the documents were acknowledged to be received. As a result of that, we did very well. I think we mm-hmm. successfully got everything we asked for.
Well, okay. So in other words, sometimes, for whatever reasons, the agent hasn't really put together a complete report, and hasn't. In that particular case, it sounded the agent must have misplaced some documents or something.
Well, it was a damaging set of documents mm-hmm. that was favorable to the taxpayer. Mm-hmm. Sometimes, there's pressure from the group manager to get a certain result.
No.
Yes. I mean, we have a current case like that. It doesn't happen often, but mm-hmm. sometimes so there's a lot of reasons why you need to be at the top of your game at appeals.
Yeah. So, when you get to this point, I mean, even if I had an appeal that I was dealing with, I would have somebody really that was more experienced with me, somebody like yourself or, an attorney in this area that's dealt in this type of litigation. There are even some CPAs and so forth that are actually licensed to represent in front of the tax court. And so again, so they tend to have more background in the legal representation area, where I'm more oriented to documentation and so forth, and
Well, it's becoming more difficult now because the tax court, when I started out, mm-hmm. was a much simpler jurisdiction procedures. Today they have more complexity, and I think while it's true that CPAs who have passed the tax court exam can practice there, I don't think it's wise because of the complexity. It's almost difficult for lawyers to keep up with their changing the rules and the nuances. Mm-hmm. And you have to understand that the tax court is more pressurized towards the federal rules of civil procedure. Even though they have their own tax court procedure, they have more complexity going on, as opposed to where it was 30, 40 years ago.
Yeah. So, are there hazards to going to appeals as opposed to just trying to get directly to tax court or something like that? Or?
Well, going to appeals, theoretically, they can raise new issues. But in my career, I haven't seen them do that. Because if they raise a new issue, the burden of proof is on the government. And I always like to see the burden of proof on the government, because why do I say that? The government, the IRS, is represented by IRS counsel. They are used to the taxpayer having the burden of proof. So when they have the burden of proof, there's sort of like ducks out of water. I mean, you might, there's exceptions. There's some really good IRS lawyers who have mastered the burden of proof. But most of the time, they're ducks out of water. So that's the only thing. If the appeals raises a new issue, they have the burden of proof, the IRS.
Okay. Are there glitches in the procedures that can arise between the original audit and the right to go to appeals?
Yeah, the glitches can come up, however, the glitches would be between the examination division and appeals, as opposed to IRS counsel sending the files to appeals. I find that the glitches could be lost files. The glitches could be that the audit isn't complete and the appeals officer needs more and would refer it back to examination division to make a better case.
Yeah. Can you give an example of how a case might be settled based on the hazards of litigation?
Yeah, particularly in a fraud case, you would have the hazards of litigation. The government, IRS, has the burden of proof. So if you mount evidence of the case where they can't make fraud by clear and convincing evidence, you would end up with no fraud, which is what you really want, and maybe a lesser penalty like the negligence penalty. Also, recently I've had a case about real estate professional. And the government resists the IRS because a lot of people like to convert their hobby of buying houses, real estate, into, and say they're a real estate professional to take the deduction.
Right.
But there are litigating hazards. And in one particular case, we were able to document. And while I don't like to bring the client, the taxpayer, to a meeting, this particular client and taxpayer was so proficient, so detailed oriented. I did bring the client to the appeals meeting, and as a result of that, in an area, real estate professional, where the government hardly gives up any case,
right,
they gave up the case.
Interesting. Okay. What happens when there is no satisfactory resolution at appeals?
Well, excuse me. If there's no satisfaction at appeals and settlement, you would go to trial.
Yes.
And trial requires preparation by discovery, by meetings, by agreeing to stipulation. Tax court likes stipulations of facts and mostly likes to resolve the case if they can on stipulation. I particularly like to go to trial. I've liked to go to trial when I was a government lawyer, and I like to go to trial in private practice. And I think that helps in getting good, fair settlements because I'm not afraid of the trial. And so if you prepare properly with stipulations, discovery, you end up with a trial. How does this trial occur? Tax court issues a notice. We're going to have a trial session in San Francisco in June. Usually the notice comes 6 months earlier. So you have 6 months going back and forth with discovery, stipulations, and settlement. And then during that process, the government sometimes says, I don't want to go to trial. We'll settle the case. If they don't want to settle the case, then we go to trial. And what happens at the trial? The tax court will say, okay, we have a session that starts on a Monday, let's say, and we want to know how many hours you think the trial will occur, and we'll assign you a trial date. And when the trial date comes, if you have the burden of proof, normally the taxpayer, you go first and you put on your case. The government then responds by putting on its case. How does that happen? You have witnesses and documents. And if the taxpayer petitioner puts on the case, the government cross-examines the witness. When the government puts on its case, you cross-examine the government's witnesses. Could be a revenue agent, could be somebody who is a competitor, an ex-spouse, whatever. So when you have the trial can last several hours or several days. At the end of the trial, the government and the taxpayer petitioner get from the judge, okay, you will file briefs. You file the briefs according to either simultaneous or seriatim. With seriatim, petitioner usually goes first, government goes second, petitioner goes in reply because of the burden of proof. Send those briefs away to Washington, D.C., where the tax court has its headquarters, and you wait. Could be 3, 6, 9, 18 months before you get a decision. This is unlike if you want to go to the district court. In a district court, in a refund suit, you got to pay all the tax and interest. Claim the refund, wait at least 6 months. If the government doesn't act 6 months, you could file a lawsuit. If the government disallows the claim, you can immediately go into district court. Now, the difference between a tax court and a district court is tax court, no jury, just a judge. In district court, you can claim and ask for a jury trial. And you can then go forward with the case. It used to be that the district court refund actions were more complex, and they are more complicated. So from a taxpayer's point of view, you need to have more money available for attorneys and costs if you go to district court. The tax court used to be a less expensive court, but because the tax court is becoming more complex as to its procedures and rules, it's narrowing the expense item. Not a good thing for taxpayer clients because they're going to have to spend more money on lawyers and costs. Nevertheless, in a district court, you can get almost instant result because if it's a district court judge can rule from the bench. If it's a jury trial, you get immediate result at the end of the jury verdict. So those are the two complexities. Each forum, however, tax court and district court, you can appeal. And then here in the California, it's the Ninth Circuit. So you can go to the same place, but it could be from a different venue.
So just to highlight again, so with the district court, you have to pay the tax before you go to district court, where the tax court, a lot of people like it because you don't have to pay the tax before you have your case heard.
Right.
So
you
maybe
can
you can talk a little bit about the situations of, again, and then you talk about that you could have a jury trial for district court where basically you just have the judge for the tax court.
Yeah, there's one other option here. In a refund suit, you could also go to the claims court in Washington, D.C. And the claims court travels around, but there's no jury. So, but you still have to pay the tax and the interest.
So when you're deciding which one that you're going to choose as far as having your case heard, is there any strategy or thoughts that you have behind that?
Yeah, it's complex. It depends on it depends on the issue. It depends on if you research the cases. Like in the claims court, there were certain cases that are more favorable to the taxpayer, and if you have that same issue, you want to go to claims court. Also in the district court, you can research the issue. Let's say in the Northern District of California, to see how the refund suits came out. In the tax court, you see how they do. I mean, some issues, they're not very favorable to the taxpayer. So you have to see that issue of how they've decided past cases. If not, then you have to consider what the witnesses are, what the documents are, and not insignificant is what the cost factors are. Mm-hmm. I mean, that may be a significant factor. Like you just alluded to, in the tax court, you don't have to pay the tax up front. Right. Just the $60 and the filing fee is $60, and then you go forward. So that may be the most practical leveling factor, is the expense, the cost.
Right. And now, I mean, and they also have like a small case procedure, I guess. So some people are even representing themselves before the tax court, but I think that there's a higher loss factor related to when people make that decision. But anyway, I guess it is a less expensive and so forth. Right. Procedure. Or you have
small claims procedure, you don't have an appeal right. Mm-hmm. So, and in the tax court, there's a lot of pro se cases, which are individuals representing themselves. And there is, the Bar Association has a group of lawyers to assist and aid the pro se taxpayers to make the proceeding more efficient, because they're not well versed in evidence rules and procedural rules. So I would not suggest that you go to court as a pro se. And if you have a small issue, an insignificant issue, like say personal exemption type of issue, or maybe substantiation on travel or something, maybe it's appropriate to go pro se. But generally speaking, you don't really come out very well doing that.
Yeah. Well, I mean, I've seen an awful lot of these pro se cases, and even some cases that aren't so pro se, and you wonder how the heck this person ever got to this point, whether before the tax court or a district court, because it seems, pretty clear what the result would be in the first place. I don't know. So, and that's, I think, a good reason for getting good representation or advice in the first place. And so some people, I think that they have their own beliefs or whatever, about what the results should be, and so it's a matter of principle that they're going to argue this thing, but it's not going to have the result that they're hoping for.
Well, you just outlined is a reason to have an early settlement, mm-hmm. as opposed to pursuing the litigation aspects. So if you have that kind of a case, you want to settle that case soon.
Yeah, and unfortunately, again, because these people, for them it's a matter of principle, then we're getting away from rationality and we're talking about emotion. And
well, if you have that kind of principle, yeah. And you have the money, go for it. Mm-hmm. And just, it's like going to Las Vegas and gambling. You're going to most likely lose.
It reminds me of a case that actually I think it got all the way to the Supreme Court years ago, and I think it was a Mormon family, and so this guy said, I don't get it. I've got 20 exemptions, and they say that I owe this alternative minimum tax. That can't be right. And the judge said, I'm terribly sorry, but that's what the law says.
Right.
So we just have maybe a minute left. Maybe you'd like to throw out, some final thoughts related, or a final thought related to this area of appeals and tax court.
Well, my final thought is always go and exercise your right at appeals, and don't be shy about going to either tax court or district court, but get competent representation. As you may well stated, exercising your emotions as a pro se is foolish unless you have money to burn. You're better off having proper representation, because either you settle it early or you litigate, and with the chances of winning. So that's my observation.
Yeah. Martin, I want to thank you again for joining us.
Well,
and
thank you for having me.
Sharing your wisdom related to this and experience. So, folks, I think this has been a great opportunity to have Martin share his knowledge with us. But if you are dealing with an IRS appeal or tax court type of a situation, or thinking of going to district court, you definitely do need representation. This is not a do-it-yourself job. We'll see you next time on Financial Insider Weekly.